Good afternoon, everybody. Thank you very much for joining us this afternoon. I'm Nicola Lennard. I'm one of the medico-legal advisors here at the MDU. I'm pleased to say that I'm joined today by Bansari Patel, who is a solicitor from our in-house legal team, and by Dr Nandasoma, who is our head of advisory services. We're going to spend approximately an hour today just discussing the intricacies of preparing for an inquest and how you can minimise the risk of being criticised when giving evidence at an inquest. This session is going to be recorded, and so if you want to watch it again, you will be able to watch it on demand through our website. We are also going to spend hopefully 15 to 20 minutes at the end of this presentation answering some questions, and you are able to post your questions. If you could do that as early as possible during the presentation and try and keep those questions nice and short and concise. We can't promise to answer them all, but we'll answer as many as possible. I should also say that you will be emailed a certificate of attendance sometime over the next week following your attendance at the webinar. So we're going to begin with just a few straw polls, which we'd like you to respond to, and those should begin in the next moment or so. So to start off with, we're going to ask you if you've been attending an inquest previously, and do you feel confident in writing a report? Whilst you're thinking about that question, I'm just going to put up an e-learning resource in the questions section, which is a new e-learning resource about completing death certificates and referring deaths to the coroner, which you may find helpful to have a look at. So just looking at the response to that poll, we've had 76% response, and of that, 29% of you feel confident writing a report, but 71% said that you didn't feel confident. So hopefully we can address that concern through this presentation today. If we move on to the next poll, have you ever been asked to attend an inquest? For those of you who are just joining us at the moment, we're just going through a few straw polls on your experience of inquests and writing reports. So please feel free to just add in your answer, and we'll go through some of the queries that arise. So it looks as though it's almost a 50-50 split in terms of those of you who've been asked to attend an inquest. 51% said yes, 49% said no. And I do appreciate that it's really quite stressful to have to attend an inquest. So if we move on to our final poll, what is it that you find most worrying about an inquest? Is it being criticised? Are you just generally nervous about the process because you're not entirely sure what is going to happen? Or are you not concerned at all? Are you happy to attend an inquest? Happy, possibly not the correct word there, but would you be confident to attend an inquest? Okay, so looking at that, it's a sort of 60-30 split between 60% being criticised at an inquest and 30% just being nervous of the process as a whole. And certainly Bansari in particular will be looking at what can give rise to criticism and how to avoid that a little bit later on in this presentation. Okay, we're going to move on to the slide deck now. Or maybe if I can get the slides to move. Apologies, my Computer appears to have frozen. Oh, there we go, got the problem sorted. So this was a survey that was done, I think, back in 2020 of our members, and the question at that time was, have you ever been asked to attend an inquest? And it is quite interesting to see that the vast majority, 40%, had been asked to attend an inquest between 2 and 5 times, which is quite a considerable number. I know it is something that makes a lot of doctors concerned, and so hopefully we can address some of those concerns today and give you a little bit more confidence in how to approach an inquest. So the things that we're going to look at today really are what deaths need to be notified to the coroner, how to write a report for a coroner, and how should you approach appearing at an inquest and giving evidence. Bansari is then going to speak to you a bit more about the implications of being criticised at an inquest and how to reduce the likelihood of that happening and what to do if you are criticised. So I hope with all of those topics we'll be able to give you all a bit more confidence and also give you the advice of what to do when you're contacted by a member of the coroner's office. So we'll start with just a brief look at the types of deaths that need to be notified to the coroner. And these are listed in the Notification of Deaths Regulations, which came out in 2019, and it's Regulation 13. And I don't think you'll be surprised by the types of deaths that have to be reported for the coroner. For the most part, I suspect that you will be involved in deaths arising from trauma or injury or violence, sometimes in relation to medicinal products. If the death has been attributed to some form of treatment, or if there's been an injury or disease that's attributable to employment, such as asbestosis. That's not an uncommon one to find. But in addition to these, the coroner does have a reasonable amount of discretion and can use that to open up inquests into other deaths that might not necessarily fit into those criteria. And they can take on board the impact of other issues, such as if there are significant concerns or complaints by the nearest relative of the deceased, or if there might have been an adverse incident in relation to the patient's death, or if the death may give rise to some form of public anxiety. So it's worth remembering that the coroner does have a reasonable amount of discretion as to which deaths they investigate. I should also say that referrals to the coroner are not generally made as an emergency. You should report the death as soon as possible after the death, and preferably within 48 hours of the death, but it wouldn't be necessarily usually to make that referral, say, over a weekend period. I think I've only ever had to do that once, and that is in relation to transplant and organ donation prior to surgical, before removing organs. So I thought it'd just be helpful just to think about things in the context of scenario. So in this case, we've got a junior doctor who has contacted us because they've been asked to write a report for the coroner. And it's following the death of an elderly patient who was on warfarin and who had a fall whilst an inpatient. Now, the doctor had been asked as the on-call doctor to assess the patient following the fall. They'd noted various findings, including the bruise on the side of the head. They'd done a neurological examination and felt that that was unremarkable, but did note that the patient was slightly confused and sleepy, but had been told by the nurse that was looking after the patient that that was normal for the patient as she had an element of dementia. The doctor also remembered giving the nurses or asking the nurses to continue to do neuro observations on an hourly basis. But sadly, that didn't happen. The patient deteriorated overnight and was found dead in her bed in the early hours of the morning. A post-mortem examination was performed, and this revealed that the cause of death was an acute subdural hematoma. So the doctor's been asked to give a report to the coroner. Now, I have to say that this has been exaggerated for effect, but it's not unreasonable for us to unusual for us to see relatively brief reports such as this. And unfortunately, this is not the most helpful way to present a report to the coroner. For instance, if you look at this report, you don't know what date the doctor saw the patient or what time. There's a number of various different abbreviations in there, such as query NOF and SHO. The coroners these days are unlikely to be medically qualified. They're generally legally qualified. And so you need to bear in mind who you're writing the report for. It's got to be able to be understood by an individual who is not medically qualified. In addition, you should bear in mind that the family are also likely to see the report. So if we could just move on and have a look at what advice the doctor was given in terms of drafting the report. I should say that we've got quite a bit of guidance on our website, which gives advice on how to write a report for the coroner, and that's always worth having a look at. But I would also recommend that you contact your defence organisation as soon as you're asked to write a coroner's report and get advice early. So if we look at this modified report, we can see that the doctor's provided a bit of information about himself. It's helpful for the coroner to know the degree of experience that the doctor has and the level of expertise that they're working at. It also helps them to know a bit about their working role. How many wards were they covering? How long have they been working at that hospital, for instance? Equally, when you're writing a report, if you are mentioning other members of staff within the report, you should ideally name those individuals and provide the factual account of their involvement, but not comment on their involvement or certainly not criticise it, just provide a factual account. Your account should be a chronological report so that you can be understood easily, and if it's read out in court, it is easy to follow. And if you do use medical terminology or jargon, it's helpful to explain that so that a lay individual can understand. So for instance, here we've got warfarin and then an explanation that that's a blood thinning medication. And if you note in the second paragraph, there's an explanation of Glasgow Coma Scale, and that's divided into its relevant sections. You'll also see in this report that the doctor has given a much more detailed account of his assessment. When writing a report, you can include within that report information that is documented in the medical record, information that you can clearly recollect, and information about what your usual practice would be in a certain situation. And it can be very helpful to make reference to all those different sources of information. So when providing your report for the coroner, these are the sort of main points that I would want to be thinking about when drafting a report, and certainly the main points that I look at when I'm reviewing reports for the coroner. You'll appreciate that we see quite a lot of reports for coroners, and so it is helpful to seek advice from your defence organisation just to get that extra pair of eyes to look at it. Someone from the outside looking in who can say, but why was this? Or can you give a bit more explanation about that? Okay, you'll notice the last point there, it says keep your report factual and stay within the bounds of your knowledge. It's really important just to stick to the facts. The coroner is not asking you for an expert opinion. It is open to the coroner to ask for an expert report. Because you were involved in the care of the patient, your role is simply to provide the facts of the case. The coroner has the power to seek reports from many individuals involved in the patient's care. They may seek a report from the general practitioner, as well as hospital doctors. Equally, they will have reports from potentially pathologists, and as I've said, they can also seek expert reports as well. It's really important when you write your report that you cross-check what you've written in compared with the medical records, just to make sure that there's no factual inaccuracies. It can also be helpful to mention if there has been a significant event meeting discussion. I know that those quite commonly happen, and we will certainly recommend that in certain situations, not unusually. Certainly in general practitioners' cases, it's helpful to discuss the patient's care if they've been seen regularly within the practice, just to see if there have been any learning points in relation to the patient's care. It may be helpful to disclose those to the coroner at an early stage, but again, I would recommend that you seek advice from your defence organisation about that. I think the most important thing about getting a good report into the coroner is that in some cases it may remove the need for you to be called as a witness, and it may be that the coroner would be happy just to read your statement in court and you wouldn't have to go and answer questions at all. But even if it doesn't achieve that, it may be that you maybe answer the vast majority of the coroner's and the family's questions with that report, and therefore it reduces the amount of questions that you might be asked if you do have to go and give evidence. So it's very definitely in your interest to give as detailed a report as you can. So if you think back to our doctor again, he's submitted his report via the trust, and he's gone to a different training post. And several months later, he is made aware that he is going to be required to attend the inquest. And he's also told by the hospital that there was a root cause analysis investigation, which had been critical of his management of the patient and also the nursing staff. And the hospital trust legal team suggested that he should speak to his defence organisation to see whether he needs separate legal representation from the trust at the inquest. So when you're asked to attend an inquest, you may be invited or you may be summoned. If you're summoned, you do not have a choice. You will have to attend. Albeit the attendance might be in person or can be virtual these days. We're seeing a rise in the number of virtual inquests. But if you are summoned, you will have to attend. If you've been involved in the patient's care, you will be a witness to fact. But one thing that you will need to check is whether or not you've been designated as an interested person. And by interested, we don't mean a particularly curious individual, but we mean someone having a stake in that person's death. In the regulations, it says a person who may, by any act or omission, have caused or contributed to the death of the deceased. And being an interested person affords you certain rights and allows you to be legally represented at an inquest. In general, in a lot of the inquests that we help doctors with, there isn't a need for doctors to have legal representation at an inquest. But the things that you need to look out for and the warning signs are if the family have got their own legal representation, if there's been care of your criticism of the care that you've provided, if you've been named as an interested party, or if other individuals who are giving evidence have their own legal representation. Equally, if you're a hospital doctor, if there's been a conflict between you and the trust, such as a critical root cause analysis, then that might be a requirement. It might be a reason for considering legal representation. But in all cases, what I would suggest is that you seek advice from your defence organisation. So, just a few quick words. Attending the hearing. Dress up, turn up, stand up, look up and speak up. One of those old sayings about how you should attend an inquest. I think Bansari is going to speak a little bit more about giving evidence at an inquest, but we'll just briefly look at some tips prior to attending the inquest. Important to have gone through your own report several times before arriving. You don't need to know it off by heart, but it can be helpful to mark up the important bits and also within the notes highlight the relevant points. You are able to refer to your notes when giving evidence, but you should usually ask to do so. You'll see that I have put down here that you have no obligation to answer questions that could lead to a criminal charge. If you have any concerns that there might be a criminal charge that might arise, firstly, I would hope that you've sought advice before the inquest, but if that became apparent, and that would be an incredibly rare occurrence, I don't want to alarm you at all, then you can ask to seek legal advice at that point. When you give evidence, you generally be asked questions by the coroner. You might be asked questions directly by the deceased family or the legal representative. In some cases, there is a jury and they too can ask questions. And if you have your own legal representative, they may ask questions of you for the purpose of making a point or clarifying something to the coroner. The coroner is there to see fair play and should intervene and exclude any inappropriate questions. You can imagine that inquests can be quite somber, but can sometimes be quite charged events. And so it can be understandable that families can get deeply upset and might keep wanting to ask the same question, but hopefully the coroner should manage that for you. I think one thing that you do need to remember when giving evidence is that as doctors, we're trained to give an awful lot of information and to try and give the patient as much information as we can about the disease, their treatment, and what they can expect. The approach in answering questions in court is a little bit different. You need to listen to the question very carefully, consider what you're being asked, and then just answer that question. Don't keep trying to add additional information. Limit your answer to the specific question. And don't try and preempt questions that you think might be coming next. It is reasonable to ask if you've not fully understood the question, or if there are multiple questions with one question, you can ask for that question to be broken down into its separate parts. As I've said, you can also ask to check the facts within your notes if you're unsure. Beware of questions that are trying to tempt you into speculating about matters. You should avoid answering those. And when answering your questions, what I would recommend is that you direct your answers to the coroner directly. So what happened to our doctor? The doctor was assisted by a medico-legal advisor, and an MDU solicitor was appointed to help prepare that member for the inquest. As the root cause analysis was critical of the doctor, it was felt appropriate to instruct a barrister to represent the member's interest at court. The doctor indicated, with the benefit of hindsight, he could have perhaps discussed the patient's care with a senior doctor or considered doing a scan. Fortunately for the doctor, the family were not specifically critical of the member, focused instead on the failings of the nursing care of the patient. But the conclusion of the inquest was that the patient died of natural causes, but there was a rider of neglect. So in summary, when you're asked to give a statement, seek advice from a defence organisation at an early stage because they can help you get a good report developed and submitted and can advise you on the inquest process as things go forward. As always, it is important that you are completely open and honest in your report, and that if there are lessons to be learned, that those lessons are learned at an early stage. I am going to hand over now to Bansari, who's going to talk a little bit more about giving evidence and the potential for criticism and how to avoid that going forwards.
Okay, I shall just share my presentation first of all, and Nicola, hopefully you can tell me whether everything appears as it should do on the screen.
I can see your presentation, Bansari.
Okay, excellent. Right. Okay, so when I was putting this talk together, I had in mind that I wanted it to be very practical, and I wanted you all to know, in the event that you're invited to an inquest, exactly what you need to do to reduce the likelihood of your being criticised. So I've created a 7-step plan. And I noted from the first poll, or maybe it was the third poll, that 62% of you are nervous about being criticised. So hopefully this will leave you feeling a little bit more empowered. So first of all, step 1, seek advice, and seek advice early. I've met many doctors who have waited until shortly before the inquest, or even during the inquest itself, to seek advice. Ideally, the time to seek advice is before you submit your statement. Now, I've noticed that many doctors are hard on themselves and quick to criticise themselves. So it's important to take some time to reflect on your involvement before you submit that statement. And I'll give you an example. A few years ago, I represented a doctor who was asked to submit a statement by the coroner, and he fired off a letter in which he said essentially, "It's all my fault that the patient died and I'm really sorry." The coroner disclosed a copy of that letter to the family, who were understandably angry and upset. And it was only at that stage that the doctor contacted the MDU for advice. And when I interviewed him and we went through matters in some detail, he reflected and he realised that actually this wasn't his fault. Now, fortunately, we were able to rectify matters by submitting a detailed statement, setting out very clearly and simply what he had done, and more importantly, why he had done it. And happily, the inquest concluded without any criticism of him. But obviously, it would have been better if he'd sought advice before submitting his statement. Now, Nicola has already provided you with some great advice on statement drafting. I just wanted to add a couple of points to that. First of all, drafting a statement is a skill, and a beautifully drafted statement will serve you well, not just at the inquest, but potentially beyond the inquest, and I'll say more about that later. When I draft statements on behalf of doctors, I consider what the coroner might be thinking, what the family might be wondering, and I bear in mind, as Nicola noted, that they might not necessarily be medically qualified, and I draft the statement accordingly. I think it's very important to realise that it's easy to be critical of someone if you don't have a full understanding of what they did, and more importantly, why they did it. And if you're not medically qualified, then you may well not have a full understanding of what someone did and why they did it. So when I draft statements, I try to explain not only what the doctor did, but why they did it. And I'll give you an example. Sometimes I see in statements, I made a routine referral. It's better to say, I made a routine referral because it's very easy to say, well, you should have made an urgent referral, particularly when you're looking at a case with the benefit of hindsight. So it's good to explain the reasons that you made a routine referral rather than an urgent one. So because the patient's observations were normal, he looked well, he didn't meet the criteria for an urgent referral or whatever. Also, when I'm drafting statements, I try to anticipate any tricky questions that I think might be asked by the coroner or the family's legal representative, and I try to weave those answers into the statement. So I'll give you another example. I had a case where the doctor decided to refer the patient on, say, the 10th of January, but for some administrative reason, that referral wasn't sent until the 10th of March, so 2 months later. Rather than wait to be asked why there had been that delay in the witness box, we decided to address that head on in the statement. and also to say what had been done to stop that particular administrative error from happening again. The advantage of that approach is it reduces your time in the witness box. It eases the pressure on you because then you're not anticipating this scary question. And also being open and honest from the outset increases your credibility before the coroner. Nicola also touched upon interested person status. So you might want to seek advice on, in circumstances where you haven't been named as an interested person, do you need to be named as an interested person? Essentially what you're asking is, do you keep your head below the parapet or do you stick your head above it? Now, having interested person status conveys a number of advantages, one of which is that you're entitled to have sight of the other statements, medical records you may not have access to, any expert reports that the coroner has obtained. It may be that those other documents contain inaccuracies or criticisms of you. And of course, forewarned is forearmed.
I'm sorry, it's Ed here. I think your slides have frozen. Charlie's going to try and sort that out. So could you pause for just a moment and we'll reshare?
On the correct slide, Ed, on the first slide that says seek advice?
Let's try sharing again and yeah, crack on.
Okay. So do you want me to continue? Can you see the slides? Okay, I'll carry on unless anyone tells me otherwise. So essentially,
Bansari, I think you just need to, can you reshare them? I think you need to reshare them and then hopefully we'll be able to see them.
Okay, bear with me. Okay, can you see them now?
Yeah, perfect. We're on the seek advice slide.
Excellent, fantastic. So apologies everybody for that. So I think I was just saying that it's better to be aware of any criticisms or inaccuracies in any of the documents that the coroner is looking at, so that you're not taken by surprise and you can respond accordingly. Step 2, consider doing a significant event analysis. So coroners often ask if one has been done and request a copy, but if they don't, you might want to do one anyway. The advantage of this is that it's an opportunity to provide reassurance to the coroner. I'm going to use this word reassurance a lot during this talk. If you have identified shortcomings in your practice, then doing a significant event analysis is an opportunity to provide reassurance to the coroner that the clinicians involved have reflected and, if appropriate, taken remedial action. If you haven't identified any shortcomings, then it can still be reassuring for the coroner to know that a number of clinicians have reviewed the case and they're satisfied that everything that should have been done was done. And this is something you might want to refer to in your statement to the coroner. Step 3, you might want to consider doing an audit. I had an inquest where, owing to an administrative error, a referral had been missed. So this is an example I often use, and it wasn't made for a couple of months. The practice undertook an audit which showed that within a defined period, the vast majority of referrals had been made within 48 hours, and where that hadn't happened, there was a good reason. And we decided to disclose a copy of that audit to the coroner to reassure them that this wasn't a common occurrence. Step 4, complete relevant CPD. So as you all know, there are many online and in-person courses that you can do. Sometimes it can be difficult to find something that's relevant to the particular circumstances of your case. And where that happens, you can also read relevant journal articles or relevant book chapters. If you do that, then you should keep a list of what you've read and record the date that you've read it. The advantage of doing some CPD is not only will it enable you to reflect on your involvement in the case, and I spoke about the importance of reflection at the beginning of this talk, It may also be helpful when you come to give evidence. It may mean that you're more confident, you're more articulate when talking about the clinical aspects, you're up to date, and therefore you're a more impressive witness. And again, it's something you might wish to mention in your statement. And you could do that in a number of ways. So for example, you might say, I've done a refresher course and I've altered my practice accordingly. Or you might be saying, I've done a refresher course which has reassured me that I performed the procedure correctly. CPD will also stand you in good stead post-inquest if you are criticised, and I'll say more about that later. Step 5, revise. So you should know your statement and the medical records like the back of your hand. Having said that, giving evidence is not a memory test, and you should have with you, when you give evidence, a copy of your statement and the medical records to refer to whenever you need to. If the coroner asks you a question, there's nothing wrong with saying, do you mind if I just refer to my statement, or do you mind if I just refer to the records? But it will make life easier for you and the coroner if you're able to find relevant passages within the medical records quickly. And it will be easier to answer questions if you're familiar with the statement and with the records. Step number 6, you may wish to attend an inquest. Inquests are public hearings, which means anyone can attend. If you would like to attend an inquest, then the best thing to do is to telephone the court, explain that you'd like to observe an inquest, and ask when might be a good time to do so. Don't just turn up, because it may be that you turn up on a day when there isn't an inquest or there aren't any witnesses giving evidence. The advantage of doing this is that it should hopefully put you at ease when you come to give evidence yourself, as you'll be familiar with the process, with the format of proceedings, with the environment. It's also incredibly useful to watch other people giving evidence. It's useful to see what a good witness looks like and what a bad witness looks like. So watching others give evidence will teach you not just what to do, but also what not to do. I've seen many unattractive witnesses in my time, so thankfully not the people I've been representing, but other witnesses in court. Unattractive witnesses are sarcastic, argumentative, defensive, they don't answer the question, they ramble on. Your aim is to be an impressive witness. So that brings us to our final step, step number 7. Be an impressive witness. So what is an impressive witness? When I interview doctors, I always consider what sort of witness they'll make and whether they'll present as having or being the 3 C's. So the 3 C's are competent, caring, conscientious. I think that even if there have been shortcomings, if you present as having these qualities, you're less likely to be criticised. This is another tip that Nicola mentioned, being well dressed. You don't have to wear a suit necessarily, but the smarter you are, the better. Where appropriate, be insightful, be reflective. If the coroner asks you a question, there's nothing wrong with pausing for a second to think about it. Now, Nicola has mentioned the answer the question asked tip before, but I wanted to emphasize this. A colleague of mine always says there's no magic to giving evidence. There are just 2 rules: answer the question and tell the truth. If you don't answer the question asked, and instead you answer the question you would prefer to answer, or the question you think you'll be asked, all that will happen is that the question will be repeated and you will look evasive or defensive. And I've added the words "and stop" because I know that people do have a tendency to ramble on when they're feeling nervous, which is understandable. And another colleague of mine uses a really good example using a pen. So he holds up a pen and he says, "What's this?" And he says the answer is, "It's a pen, full stop." You don't need to talk about the length of the pen or the color of the pen or the make of the pen. If someone needs that additional information, they can ask you. So you can say "a pen" and then stop. A word about emotion. Many doctors have said to me that they're very upset about the death of their patient and they're worried about bursting into tears when they give evidence? And my answer to that is always, don't worry. Of course, we all want to maintain a professional appearance, and we don't want it to be suggested that we're trying to shift the focus from the family of the deceased. But crying in the witness box, even for professional witnesses, happens not infrequently. And of course, it will show that you care and that you've been deeply affected by what has happened. So if, despite having followed the 7 steps, you are criticised, what should you do? Well, whenever I represent a doctor at an inquest, I always bear in mind the possibility of GMC involvement. So how might the GMC become involved? Well, the coroner can refer you, the family can refer you, the public can refer you. I had an inquest a few years ago where there was no criticism of my doctor, but a member of the public who was present during the inquest decided to write to the GMC about his concerns. Now, I think that's exceptionally rare, and I suspect that that so-called member of the public was in fact related to the family, but I mention it for completeness. The GMC can refer you to the GMC. So I've had a couple of cases where the press have published an article about the inquest. Someone at the GMC has read that article, and that's led to a decision to investigate the doctors involved. And then finally, you can refer yourself to the GMC, and there are certain circumstances in which you're obliged to do so. So good medical practice says that you must tell the GMC without delay if you've been criticised by an official inquiry. And then there's separate GMC guidance called Reporting Criminal and Regulatory Proceedings, which defines criticism and inquiry. So it explains that it's criticism that relates to serious matters that could call your fitness to practice into question, and that an example of an inquiry is a coroner's inquest. Now, this is an important point to note. Just because you have to refer yourself to the GMC, it doesn't mean that the GMC will definitely open an investigation. So how do you reduce the likelihood of a GMC investigation? I said at the beginning of this talk that you should seek advice before you submit your statement. And similarly, if you are criticised, you should seek advice before you contact the GMC. If you're in any doubt as to whether or not you've been criticised, or whether any criticism meets the threshold for self-referral, then you should seek advice. Because even where it doesn't meet the threshold, it might be tactically advantageous to self-refer. So for example, if the family is likely to refer you, then it might be best to get in there first. When I represent doctors who have been criticised, I advise them to notify the GMC not only of the criticism, but also what they've done in terms of their learning and reflection. So this is your opportunity to reassure the GMC by sending copies of your CPD certificates, your reading list, your significant event analysis, your audit, etc. It's really helpful if you can show that you undertook your learning and reflection before you were criticised. The only other thing is, at this stage, you may wish to refresh your knowledge of good medical practice and then mention that in your letter to the GMC. So this is a crude example, but let's say your record keeping is criticised at an inquest. You might want to say to the GMC, I've taken the opportunity to review good medical practice, and I note in particular paragraph 19, which deals with documentation. You might also want to mention, if it's appropriate, that you don't have any fitness to practice history. If the GMC does decide to investigate, then they may ask the coroner for a copy of your statement, which is why I said at the beginning, a beautifully drafted statement will stand you in good stead beyond the inquest. But a word of warning, if the GMC asks you for a copy of the statement that you provided to the coroner or a copy of the inquest papers, you mustn't provide the GMC with anything without the coroner's permission. I wanted to mention PFD reports. So PFD stands for Prevention of Future Deaths. So these arise where if the coroner is concerned that a risk of other death will occur or the risk continues to exist, and in the coroner's opinion, action should be taken to eliminate or reduce that risk, then he's under a duty to report the matter to a person with the power to take such action. And if you receive one of those, then you have 56 days or 8 weeks to respond. Now, hopefully, you'll avoid a PFD because you've done your 7 steps and you've reassured the coroner with your significant event analysis and your audit, etc. But if not, when responding, you must provide robust evidence that remedial actions have been taken or are underway within a clear time frame. Now, having whittled on about reassuring the coroner and the GMC, it's now my turn to reassure you. I'm very conscious that involvement in inquest proceedings can be anxiety inducing for some. And I've had several doctors say to me, they've lost confidence, they're not sleeping, they're feeling really stressed out about it. So I wanted to end with some words that I hope are a bit more uplifting. Lawyers are a pessimistic bunch, and I've represented plenty of doctors at inquests where I've considered them to be vulnerable to criticism, but where no criticism has materialised and it's been absolutely fine. I've also seen lots of initially angry relatives mellow as the inquest has progressed. At the end of the inquest, they've hugged the doctor and thanked them for all that they did. I don't know what the wider statistics show, but in my own experience, where I've represented doctors who were criticised and have had to self-refer, in the vast majority of my cases, the GMC hasn't opened an investigation. So to conclude, if you are invited to an inquest, 1, don't panic. 2, prepare, as we've discussed. You've got your 7 steps now. And 3, if you are criticised, know that it's not necessarily the end of the world. So I hope that leaves you feeling a bit more reassured and perhaps empowered. And I'll leave you with the final slide, which details some resources that you might wish to make use of. Thank you.
Fantastic, Bansari. Thank you so much for that. And thank you to our audience as well. We've got some fantastic questions, and I'll give you a second for a breather whilst I just do a little bit of housekeeping. Now, we can't get through all the questions, but thank you so much for submitting them. There were a few things that people asked about their individual circumstances, in particular, somebody being invited to an inquest because they'd authored guidance that was relevant to the field. In those circumstances, I'd say, look, contact us on the advice line or email us so we can open a file and give you specific advice. I don't think we can do justice to those queries in this webinar. The other general question we had was we made references to things like interested persons, whether there is criticism, things like that. How do we find out? How do we find out if the family are represented? Well, if you're a hospital trust, the trust legal department may know. You can contact the coroner's officer, and if you've opened a file with us, these are inquiries that we would often make on your behalf to try and assess the case and see where you stand. The coroner would often let you know if you're an interested person, but it can sometimes be late in the day because coroners are also under pressure and don't necessarily look at everything you know, well in advance of the inquest. So that being said, I've got some really interesting questions. Bansari, if I address one to you first, I think you did touch upon this, but and I'll join 2 questions here. And the one here, which I think is excellent, is being criticised an official concept as opposed to someone saying that wasn't very good? And the follow-on from that was somebody concerned as to whether criticism at a local morbidity and mortality meeting from colleagues might be something they need to share with the GMC. So can I go over to you with that?
Yes, so in relation to the first question regarding criticism, I think that the author of the question is saying what happens where it's a little bit vague and is it criticism or not? This is why it's so important to seek advice. Sometimes these are really finely balanced judgments. and you can ask 2 different lawyers the same question and get 2 different answers. Because I'm fairly risk averse, my advice tends to be if you're in any doubt, it's better to self-refer, because you don't want to be in a position where the GMC finds out about that criticism, even if it's implied criticism or vague criticism, and then says that you should have referred. So I would say seek advice from someone, and they'll be able to help you with whether or not what has been said by the coroner reaches the threshold for self-referral, or even if it doesn't, whether you should contact the GMC in any event. And I think the second question was if you're criticised at a morbidity and mortality meeting, whether you should notify the GMC. Well, that's not an official inquiry in the same way, but as always seek advice if you're concerned.
Great, Bansari, and just to provide further reassurance, we know there's often a lot of toing and froing at an inquest. Parties may say things that are critical, but the criticism here really refers to the coroner's conclusion, doesn't it, in terms of what's sort of set out in that at the end of the inquest?
Yes, and the findings and the conclusion.
Excellent, thank you.
Ed, there's a question here that I think is probably worth addressing, in that we've spoken a lot about doctors involved in the care of a patient, but GPs quite often get asked to write reports when they've not seen the patient for quite some time, and perhaps the patient has died in hospital. And how should GPs address those sorts of reports?
Yeah, I mean, I think that's an interesting one, and I'll join that one up with another quick one that's come in that said, look, if we're asked for a report, is it okay just to send a copy of the medical records? Just to be quite clear, the answer to that is a plain no, that if the coroner wants the medical records, they will likely already have got them. If they want a report, they want a report, and not supplying one is likely to end up with you being called to give evidence. So that said, the coroner can ask whoever they like for a report. If you think you're fundamentally the wrong person to provide it, then obviously you can have that discussion with the coroner. Sometimes they are looking for an overview of the care and a background of the patient, and provided you are explicit in explaining what your relationship is, the source of information that you have for your records, then it's reasonable to proceed in that way. Bansari, do you have any sort of comments on that?
I mean, I have been in this situation a few times where my doctor's been asked to give evidence, but they haven't necessarily been the best person to give evidence. And of course, it's the coroner's inquiry, so it's not for us to dictate which witnesses should be called. It's up to the coroner. Sometimes I've written to the coroner just to make them aware that actually another doctor was involved in the patient's care. The coroner might have questions for them, and remind them that my doctor can only say what's in the medical records. They can't speculate on the thought processes of a colleague.
And I think that sort of touches on other things where there's a question about, comments on what about things that were done by other members of the team, or what about management decisions. I think, that sometimes you're asked to give an overview, and that's not unreasonable, but you need to be very clear about where you're coming at that from, what your responsibilities are, whether you're relying on the records or it's a management issue, whether that's out of your experience, or whether you're simply reflecting what the normal policy is in the organisation in which you work. So I've got another one here, which is of a more general one about giving evidence, and it was a question about what is the disadvantage in sort of rambling on? Is it not better to give a more complete picture? Bansari, I'm sure you've had that sort of discussion with doctors you've supported. What do you think to that?
I completely understand why sometimes when a doctor gets into the witness box, they want to tell everybody absolutely everything. But you have to bear in mind that the people in the room are probably not medically qualified, and it's not terribly helpful to give evidence in that way. Evidence has to be given in a very structured way so that everybody has time to make notes and to digest what you're saying. And again, it's the coroner's inquiry, so you really need to let them lead. and let them ask their question and just answer the question. What you don't want to do is irritate the coroner. And sometimes it can be irritating when somebody sort of gives this very long paragraph in response to a very quick question. Trust that the coroner will ask additional questions if necessary.
Great, thank you for that. And I've got a couple of one quick fire one where they said where I've had a participant sort of asking whether they can decline to go and send a solicitor instead. You are the witness, the solicitor can support you at the inquest, but they can't be sent to give your evidence on your behalf. So just to be clear on that. The next question, we've had a few on the particular position of psychiatrists at inquests and particular issues raised by deaths in suicide or deaths where, for example, a psychiatrist has undertaken an assessment for a patient detained on a section 136 when they're found disturbed in a public place, subsequently discharged and kills themselves. Have you any observations about mental health inquests in particular?
Sorry,
Sorry, Bansari, that was to you. Sorry, first.
Sorry, I didn't realise it was to me. The mental health inquests are always very tricky, I find, and I've noticed a lot more recently. I think because there've been so many suicides during the pandemic. I think they're definitely ones to seek advice on and seek advice on them early.
Yeah, I'd agree. And there's often been a significant event analysis of some sort in these sorts of incidences, and it's helpful to have known the outcome of that. Equally, if you've been involved clinically in the care of the patient, to give a very, very detailed account of the assessment that was performed and the action that was taken and the justification for that action, not just explaining what you did, but why you did what you did and on what basis within your report. That can be very helpful.
Yes.
Thanks, Nikki. I think that's a really important point.
And I was just going to add, Ed, that sort of relates to the example that I gave about saying, I've had quite a few GPs where they've made a routine referral in relation to mental health, and it's easy where somebody subsequently self-harms to say, well, it should have been urgent. So it's really important to set out why they didn't meet the criteria for an urgent referral. For example, why you referred them to for CBT as opposed to referring them to the crisis team or sending them straight off to hospital.
Great, thank you. And I'm conscious we're really close up to time, so there's a couple of big things at the end here where there's a question about how this is different from a criminal case and whether a coroner's inquest is about the allocation of blame. And I'll come to you, Bansari, for this. I know that there is the stated position and the experience can be slightly different here, but what do you think?
So inquests are supposed to be inquisitorial. They're not supposed to be adversarial, and the coroner doesn't have the power to make any findings of criminal or civil liability. But as you say, that there's the actual experience, and often you go along to these things, and it does feel adversarial. And obviously, you are thinking about the possibility of being criticised and the consequences and the implications of that.
Great, thank you for that. I'm conscious we're up to time. I can see a lot of other really interesting questions in here. Again, I'd emphasize some of them, such as how to answer hypothetical questions, really depend on the circumstances. And if you're going to an inquest and you're not sure how to approach some aspects of it, then I say, please do get in touch with us with your individual circumstances, open a case with us, and we'd be very happy to advise. But I think it's just for me to say thank you very much indeed to both our presenters and to you as the audience. I'm so sorry we didn't get to all your questions, but thank you very much for your engagement. That's really helpful to us as well.
Thank you.